So tonight we're fortunate to have here an extremely high-powered panel of people to talk to us about producer statements, particularly PS4s, and the risks and responsibilities and liabilities that can accrue from those. The presentation tonight will be recorded. We will publicise the link to that recording through our LinkedIn page and newsletters and so forth in due course, but that will be available. And I'd emphasise as well for those online, we are anticipating having a Q&A session at the end of this, and there is an online facility for posing questions that will, depending on the number of them, curate at this end and then get through some of those at the back end. We're going to pass through a few different presenters. I'll run through a brief introduction and then hand over to far more qualified people in this area. First, Paul Kirby, Engineering New Zealand's General Counsel, to give us an overview of the Bella Vista disciplinary proceedings and the case behind that, which relevance will become clear in a couple of slides' time. Amy Rutherford from Greenwood Roche is joining us to provide an outside perspective on the Court of Appeal decision that underpins the impetus for tonight. And then in succession, we'll have Craig Lewis from Lewis Bradford and CEAS, and Adam Thornton from Dunning Thornton talking to us about the impacts of recent legal clarifications on practicing engineers, after which, time permitting, we'll open the floor to discussion and a panel Q&A type situation. So the presentation tonight, really the impetus for it was a Court of Appeal decision released in the latter part of 2024, around about October, I think it probably was, that arose from a prosecution brought in the wake of this Bella Vista case that we're going to hear about shortly. And I won't say too much more about that, except for it, at least initially, sent a few shockwaves through some people, but that was, fears were somewhat allayed and a lot of good advice was developed, most particularly this CEAS Engineering New Zealand practice alert, which hopefully many of you saw. It was first published late last year, and then CEAS generously allowed SESOC to publicise that to our members. So it's been, links to it have been sent out in a couple of different fora to our members, but we'd recommend you all have a look at that. And I've already touched on the SESOC project going on or just getting underway, looking to develop construction monitoring guidance in support of this alert and the focus it's brought on PS4s and related matters. With that, I will hand over, as I said, to more qualified people. First off, Paul Kirby to set the scene on how we got to where we are.
Thank you, Nick. Can I have the clicker? Thank you. Thank you. I'm just going to give a brief overview of the District Court case and then rush quickly to there are a few appeals after that. And I'll give an overview from the point of view of the engineer. What did the engineer do? The District Court case involved the property developer and a block layer, but I've just focused on what the engineer did within that. So this is a quick overview of what the Bella Vista subdivision was. Bella Vista was a property development company, acquired land, engaged Mr. Cameron, the engineer limited, his company, in relation to work on its residential development of homes and the land. After the development started, Tauranga City Council became concerned about the quality of work, and at the same time, WorkSafe intervened due to site safety concerns over the employees, and building work ceased. Shortly after, Bella Vista went into liquidation and the subdivision work wasn't completed. Some of the facts that the district court pointed to, it wasn't part of the decision. Well, it was in the decision, but just related to substantial retaining wall construction providing site stability was not undertaken. It was part of the consent, but that was put onto the property owners to do after purchasing the property. And major depletion of company funds left the developer with no working capital. So the district court case in December 2020 following a prosecution by Tauranga City Council. The district court convicted Danny Kansian, that's the property developer, Bella Vista Limited, Bruce Cameron, the engineer, and Daryl Joseph, a block layer, for breaching the Building Act. Bruce Cameron and his company, the Engineer Limited, were convicted of 6 charges of breaching the Building Act and carrying out non-compliant work contrary to Section 40. So the key factor in there is the court held that producer statements are within the definition of building work, as they are work for or in connection with the construction of a building. So now I'm going to say, how did, and this is, I'm not an engineer, I'm a lawyer, but I'm going to point out what the court found the engineer did, what were the facts that led up to his prosecution there. So of course he completed construction monitoring PS4s that were submitted to the council. And the key parts of that I'll point to is he submitted those, I believe, on reasonable grounds that the building works covered by the above mentioned PS1s have been completed in accordance with the relevant requirements, etc. You know those words, I'm sure, better than I do. And of course, that's supported by investigations, observations, checking, and monitoring of the works on the site. So again, I've taken this from the court case, Bruce Cameron's PS4s for one property, 297 Lakes, completed site inspection. PS4 said block wall footing size, steel placement cover, polythene waterproof and foundations as per design, and he certified okay to pour. And another, he said okay, ready to pour as per design. Block wall, concrete infill, pre-pour inspection, bond beam steel, vert tied to starters, washouts clean. I think that's what it says, covers, location. So I've taken that from the decision. Then the court found, this is what he was charged with, and this is what they found, that the block foundations were not constructed in accordance with approved plans. The front wall cover to vertical reinforcing steel is 74 mil, whereas consent requires 60 mil cover with 6 mil tolerance. And I hope that means something to you as engineers. Is that something that you could find? Would you have reasonable grounds for certifying when those are the issues that were raised? So a store wall originally designed as a retaining wall but became freestanding after excavation, and there were issues with that. Rear wall, a 1 meter wall, but ended up being 2.8 meter retaining wall. That's just for one property. And the next one, construction monitoring on 301 Lakes Boulevard. The PS4, Mr. Cameron issued PS4 at footing, pre-pour and wall pre-grout stage. And he certified at reasonable belief it met the plans. Block foundations not constructed in accordance with approved plans. The front wall resulted in 49% weaker than its intended design as a retaining wall. Cover to vertical reinforcing steel is 119 mil, whereas 60 mil cover required. Rear wall built beyond design spec and footing was inadequate for an as-built wall, which was a retaining wall. Wall height 2.45 meters, allowable height 1 meter. So those were some of the findings of the court, that what they based their prosecution on. Mr. Cameron appealed to the High Court. The court held the issue of producer statements did not give rise to liability under Section 40 of the Building Act and quashed the convictions. And in the Court of Appeal, this was a Solicitor General's reference. There was a question of law, so it wasn't an appeal from the High Court. The Solicitor General asked the Court of Appeal, was the High Court correct? And the Court of Appeal said no. The issuing of the producer statements in relation to non-compliant building work can give rise to liability. And I'll hand over.
That's where I come in. So my name is Amy Rutherford. I'm a partner in the construction and infrastructure team at Greenwood Roach. And I've been asked just to comment on that decision from a legal perspective. So there's some key points that I just wanted to talk through. I don't have slides, so you'll have to listen to me, unfortunately. So the first thing is, and probably the most important, is we now have clarity around what is building work for the purposes of Section 40 of the Building Act, as there are many conflicting High Court authorities out there. Ultimately, the court said a statement by a qualified professional that there has been compliance when that is not the case will in itself be building work that is not in accordance with the building consent. So the court did note that a PS4 is not design work, provided it related to work being done on site to implement the design. Yeah, so that's an important distinction there. So for example, site inspections, construction monitoring, and provision of instructions and directions to a building contractor. So we can take from this that PS1s and PS2s unlikely to be deemed building work for Section 40, as are essentially prospective. And what I mean by that is ensuring plans of proposed work, if followed, will result in a complying building. Additionally, I just wanted to note the absence of explicit mention of standards or information in the building consent is also not decisive. The court went on to say the standard form of the producer statement creates a degree of expectation as to the form and content. And the standard of inspection to be met can be described as the standard necessary to establish reasonable grounds for belief in the assertions made in the producer statement. And it went on to say, as the statement is produced by a qualified professional, accuracy is to be expected, particularly given that it's intended the council will rely on its reasonable assurance that work is being carried out in accordance with the consent in the code. The next point is this concept of, and I don't know if it's come to you, is criminal liability for an opinion, yeah? Because that's sort of what PS4s are. So the court stated the author of the producer statement will not be criminally liable unless it's established beyond reasonable doubt that the matters certified in the statement are correct. So big question, what is beyond reasonable doubt? It's the highest standard of proof, and it only will be found if the judge is absolutely sure the accused is guilty. It's not enough to persuade the judge that the accused is probably or even very likely guilty. So whilst the importance of PS4s to the building consent system can't be understated, criminal liability in my mind is probably potentially a harsh outcome, particularly when the building code is performance-based rather than prescriptive. And what I mean by that, it sets out minimum standards building work must perform to, but not how that must be met. So there's no objective measure of compliance, yeah? The decision does leave open the possibility that an opinion is an offence. And if that opinion later turns out to be incorrect, even if the author had reasonable grounds for the opinion when it was given. This is an issue that hasn't been tested by the courts because we haven't seen another case come out since, what was it, October. However, in such situations, you'd probably expect an inquiry would need to be had as to whether the certifying professional did have reasonable grounds to believe the work was compliant when issuing the producer statement. I also just wanted to touch on the practical implications for council, who the PS4s are ultimately for, and defect-related litigation. So on the one hand, it's a positive development for councils. When issuing code compliance certificates, we know councils must be satisfied on reasonable grounds the building work complies with the building consent. Authors of PS4s, as we know, are already exposed to civil liability under the FTA, Fair Trading Act, and also for negligent misstatement. However, potential criminal liability will no doubt add to the incentive to get the PS4 right. That will hopefully increase building standards, but also mean, all things being equal, it'll be easier for council to say they reasonably relied on the accuracy of a PS4 when defending claims that they face. On the other hand, the risk of criminal liability may make it difficult to get PS4s at all or on terms that can be reasonably relied on. It is already routine for PS4s to limit liability to the recipient council at a relatively low dollar amount, given the potential civil liability. The additional risk of criminal liability may lead consultants to decline to provide construction monitoring services or heavily qualify the PS4s that they issue. If so, this may in turn require council to rely more heavily on their own inspections when they don't have the resources or that in-house expertise. Another observation I had, which wasn't not necessarily legal, but there are other potential implications that have an unintended consequence of increasing the cost of construction at a time when our government is currently undertaking a review of the building consent system to identify opportunities for greater efficiency that will reduce the cost of construction. So I think my other panel members are going to touch on these practical impacts, but I'd just like to mention consultants who are willing to provide construction monitoring services may do so, but with significantly a higher number of inspections, hence fees. And then criminal sanctions may also impact on insurance costs, and insurance may be more difficult to obtain, in particular for those who may have been sanctioned under the Act. And finally, I just wanted to touch on, while I can, the increased litigation that we've seen lately in relation to limitation periods. There's more cases last year than I've seen for the last 5, I think, testing the Building Act time bars. And the one I just wanted to touch on is the Becker Wellington City Council case. The Supreme Court's held that the 10-year long stop date of the Building Act does not apply to contribution claims. It's really important. Only applies to direct claims for damages. So what does this mean? This allows parties to bring contribution claims against third parties post the 10-year period for a further period of 2 years thereafter. And that's governed by the Limitation Act. So the 10-year long stop date, Building Act, contribution claims under the Limitation Act. Now, this brings significant challenges and uncertainties for the industry. You've got prolonged litigation risk. It undermines the industry's ability to plan and allocate risk with certainty. It creates 2 tiers of liability. You have direct claims barred after 10 years, but contribution claims will still be actionable. And it may result in defendants in building defect cases intentionally waiting to assess liability outcomes before pursuing contribution claims against other parties, thus prolonging the life cycle of disputes, creating significant time and cost burdens for all parties, and also risk of conflicting outcomes. That also has quite significant insurance impact. That's a good segue to my right.
Yes. Thank you, Amy. It's always good getting quite a variety of opinion between a simple engineer's view of the world and a great legal mind. So I'm going to touch on a couple of matters that Amy already has, just from what it means for engineers from an engineer's perspective. There's no doubt that the Court of Appeal decision has caused quite a lot of anxiety since it came out for firms large and small throughout the country. Hopefully the practice alert advisory has helped delay some of that anxiety, but Amy's just put a few other parameters that we all need to be aware of. The reasonable grounds required, I think, is interesting because with my insurance hat on, reasonable grounds really comes up in so much of our contractual matters that we look at, and ultimately will be tested if anything goes wrong, whether it's during design or on site, will be tested against the reasonable test. What a reasonable engineer or a reasonable peer would have done. Whether we were negligent or omitted to do our job properly. So, and the reasonable grounds is embedded in the very wording of our producer statement suites. Producer statements provide BCA's reasonable grounds to issue consents, and again that comes back to at a point in time, to the standards of the time, what would a reasonable peer do and how would they act? The PS4 is a professional opinion, but as the Court of Appeal judges went to great lengths, that it is based on reasonable grounds as well. So it's a professional opinion, but it's backed up by the evidence and the work that has arrived at the point of signing a producer statement. What are the grounds that you are comfortable with signing that statement? It's backed up by the construction monitoring visits, the evidence that contractors have provided, PS3s from the different subcontractors, proprietary systems, producer statements. So there's quite a body of work there, and the flip side of the anxiety that this decision has caused for the industry, I believe has presented us with a great opportunity just to re-examine, as CESOC are, for the construction monitoring piece you're about to embark on, what good looks like. And it helps us reinforce what good behaviours are in the way that we operate. And I'll touch on some of those shortly. But yeah, the reasonable grounds required really is ensuring that our producer statements, our PS4s, accurately reflect compliance with the building consents, backed by thorough monitoring and evidence. Amy's already touched on the high burden that is noted in the appeal court decision, and that criminal liability requires proof beyond reasonable doubt. I think that's different than civil liabilities, where it's on the basis, the balance of proof sort of evidence that if something is very likely or with the balance of all probabilities put before a judge, they judge an outcome quite different from the beyond reasonable doubt. I think a great quote that I heard years ago from the Institute of Directors was, at the end of the day, don't be dumb and don't be dodgy, which I think is what unfortunately happened in the Bella Vista case. The parties were saying that they had done certain things on site, that they'd made certain inspections, that they'd done certain investigations, where it turned out that they hadn't. So hopefully this decision, if you're not dumb and you're not dodgy, will be unlikely to open the floodgates. But at the end of the day, until we get some decisions that help frame this, just about what is beyond reasonable doubt, we won't know. So what does it mean for engineers? This is where I think this issue has given us a chance just to refocus on what it means for engineers. Good practices. For a start, I hope it doesn't. For large and small projects, large and small firms, I hope this doesn't drive a desire for engineers not to contract for construction monitoring. I think again, CEAS has seen over the years with claims our members have unfortunately got dragged into, that our architectural colleagues have been too easily given away the administration and the supervisory role. They'll often get clients who just want the pretty drawings, just get me a consent, give me the documents. I don't need you to look after this project. I'll do it myself. The more sets of eyes over any project that on site there are, the better, in my opinion. And I think as engineers, we've got an obligation to monitor the work. It's embedded in our material codes that we are supposed to monitor the work that we've designed. So we should be using that as leverage to do the job properly. Personally, if I was ever bullied into not taking on a construction monitoring role, I'd walk away from a commission, because there's so many benefits to it for the finished product. But at the end of the day, it's also the last chance to pick up anything that may have been missed off the drawings, anything that, with the benefit of hindsight, would be put on. Trimmers on site, reinforcing, anything that doesn't look right. That last opportunity to see something before it's poured or constructed is vital for the thorough full commission on a project. So, I firmly believe that we should be making sure that we are engaged to do the construction monitoring role, whether that's CM3 or 4 or something else, depending on the commission, and making sure we're remunerated fairly to do that and to do it properly. Don't be pressured into partial roles or cutting corners by clients or contractors who might think they're doing their clients a favour. Maintain detailed records of the activities on site. When issuing the final PS4, clearly outline any assumptions, opinions, exclusions. We say regularly, state right back to the scope of work when you're being engaged on a project. Clearly state, what you aren't going to be doing and what you're not contracted to, as well as what you are doing. Avoid being too helpful. An eternal problem with engineers is we're problem solvers. We're always, too keen to, be the problem solvers on site. And if a particular project hasn't had an architect engaged to monitor their work, or maybe the services engineers, a limited number of inspections, the pragmatic engineer is an easy person for the contractors to ask for advice. And what would you do here? Got to be very careful, not being too helpful, and point them in the direction where you should. Please always use our industry endorsed PS4 forms. Avoid modifications at all costs. There's a huge amount of work over the last couple of decades, has gone into 3 decades, into the wording on our producer statements. The fine tuning of those is first and foremost so that they are an insurable document, and they shouldn't be tampered with. And my personal opinion is to avoid issuing PS4s, if at all possible, if you're not the PS1 author. I think there's an obvious linkage there, and I think it's very dangerous because of the correlation that's been brought between monitoring and signing off the work that is on the consented documents, if there are any issues with the quality and completeness of those consented documents. So if we've been subcontracted to monitor other engineers' work, and we do it quite regularly, different parts of the country, we will always be as thorough as we can on pre-pour inspections, provide site reports, photographic evidence, whatever support we can, but insist on the PS1 author issuing the ultimate PS4. So then, from an insurance perspective, what does this criminal liability mean? a lot of people have thought that it's uninsurable and that going to be left high and dry, and individuals and their firms and the certifying companies are going to be left high and dry. That isn't the case. A robust statutory liability insurance policy is structured for this very reason. A good statutory liability policy covers fines, penalties and defence costs for all acts of Parliament, including the Building Act. So if you haven't already, I suggest you talk to your insurers. Compared to our PI policies, statutory liability cover at the moment is very, very cost effective. For instance, our company carries $500,000 cover with a $5,000 excess, and it's less than $1,000 plus GST. It's about 0.5% of what our PI premiums are. So great peace of mind, and the advice from our co-insurers is that this is the very issue that the stat liability policy is for. Of course, affordability of that insurance, if there's a tsunami of claims under this, that will affect premium levels like all insurance does. But yeah, hopefully we're not going to see any floodgates opened, and this will be a rare case. Over to Adam.
Thanks, Craig, and good evening, everybody. Look, my remarks will be useful to all engineers, but perhaps particularly pertinent to individual, what I would call, individual authors of producer statements, who I would refer to perhaps as employee engineers. So those are engineers who perhaps don't control or have or control the insurances that they are going to rely on. So we've heard of at least there have been for some time 2 jeopardies that an author signed. That's both a commercial, that is, litigation. Oops. There we go. There we go. Sorry, I just got the slide up. So there's commercial liabilities. That's litigation. A plaintiff having a go almost always at a firm, and then there's professional, and by that I mean a complaint, and that tends to be an individual. In fact, it's almost always an individual. And then there's the statutory ones that we've been hearing about now, which is the 3rd jeopardy, and that can be both the firm and the individual. So there are penalties of 2 types for perhaps all of these. There is certainly a commercial or financial penalty. That's what Craig's been talking a bit about. So and usually those that is directed at the firm. So it's very seldom that a claim will reach beyond the firm to an individual, either to a director or to an employee. But of course, and if the firm has reasonable policies in place, that will include claims, fines, if you like, from Engineering New Zealand or from the courts. Okay, but the second, if you like, penalty relates to reputational and occupational. What I would call occupational, i.e. your ability to do your job. And that is a much more personal matter. And of course, you can't insure against that. And it's quite clear, I've been doing quite a lot of expert advice in the last few years. The courts put a lot of emphasis on the author of a producer statement. It is held in high regard. It's meant to be in high regard. So when we stuff up, there's a microscope comes on the author, and so there's some real issues there for individuals. So I guess my message is that individual authors should have very clear understanding of the support available to them, both during their employment and when their employment with their current employer ceases. Now, there are many policies that look after past employees, but there are some that don't. So the message is to just be quite clear in your relationship with your employer as to how you are protected both now and in the future. Now, what I'm talking a little about today is if you like, producer statement authorship policies. And you'll see on the side of the screen there that a document has been published. I know for sure it's available off the ACE website. I'm not sure about where else it is available, but it covers things I'm going to talk a bit about now. Firstly, from my experiences, many of you will know that I give regular seminars on producer statements across the country. And my experience from that is there is a great range in practice as to who signs or who authors producer statements. From just, in some firms it is effectively any CPeng. At one end, if you like, the scale, to the other end, it is directors only or designated technical leads only. I guess from my opinion is that the latter two are far more reasonable, and it should be aimed for. And that's for both the side of the firm, because of course the firm has a keen interest on liabilities that the firm accrues, and also for the I think it's probably fairer for the individual. I mean, there's a sort of a risk and reward balance there. And of course, directors and senior managers, they are the ones who place and understand the policies that are put in place on behalf of the firm. So I guess another one of my findings is that few firms have written policies on this subject. And so on the next page, I'm going to talk about that. But I guess, look, I think it's a pretty obvious thing from a good practice perspective is that control and review of producer statement authorship should be considered a key aspect of a robust quality assurance system. So look, this slide really is about the recommendations for producer statement policies. I'll read this out because I think it's pretty important. And so it goes as follows. All firms should have written producer statement signing policies. Such policies should include a list of authorized signatories, specific to discipline, complexity, and limits on work, value, and/or limit of liability before a particular author can sign on behalf of the firm. All signatories should be specifically authorized in writing by firm management, ideally with its authors within the author's employment contract. So an author's employment contract should list the protective measures, insurances in place for the firm and for the individual. So the professional indemnity insurance, statutory liability insurance, that's what Craig's just been talking about, legal cost cover for professional complaints. That's a big issue. Some of the legal fees for any types of these jeopardies become humongous. In fact, way more than the cost of a penalty. And it should include limits of cover, excesses, and legal costs. And as I've noted, a clear understanding of ongoing liabilities for the individual and for the firm, and insurance cover after the individual ceases to be employed by the firm. So those are things that perhaps employer-employee should discuss and have a good understanding of between them. A couple of other quick, sort of slightly more general issues to do with producer statements. And I've just put up there, it's about relying on the work of others. And I think, again, look, this is a learning to me from the seminars I've give around the countries. We all in our practice, we both rely on work from others, and people are going to rely on our work that we don't directly give a producer statement for. So as a structural engineer, I'm going to rely very much on information perhaps from a fire engineer or from a geotechnical engineer, and also perhaps from an engineer who's doing proprietary design, for a specific proprietary product. While I can perhaps exclude the proprietary product on my producer statement, that doesn't exclude it effectively in the eyes of my employer, my client, I should say. He doesn't understand that I'm not taking liability for some precast flooring, a bit of driven pile or something. He would assume, quite probably reasonably, that I'm taking responsibility for all those things. So what is my reasonable grounds for relying on work from others? I think that's something we all need to think about and make sure that we do get appropriate producer statements from people's work they rely on. And it goes up and down the chain. If somebody's relying on your work, make sure that those people who are going to rely on your work, that they have appropriate insurances, all those sorts of things, and are giving proper producer statements in relation to the work that we share. I mean, it is a collaborative effort in the end, and I think putting a lot of effort into that. And the second sort of part about relying on works of others, and particularly in terms of PS4s, is, and Craig's mentioned this already, but I'm going to reiterate it. It is about the fact that, you know, we as structural engineers in particular, there's so much stuff these days now that we cannot inspect, you know, that we're not experts in. Protective coatings, weldings, all sorts of things, treatment of timber. We are very much reliant on others doing their job in that. So how do we demonstrate reasonable grounds for signing a PS4, you know, for those things that I just mentioned. So that is you know, it's issues like quality records, quality assurance records provided by contractors and their subcontractors. You know, I'm not saying you have to get them and understand them and check every one of them, but you have to get that information and put it in to show, in my opinion, to show reasonable grounds. You know, my record, I think, for a producer statement, we had 10,000 pages of attached information. So that, you know, that's shop drawings, that's weld testing, that's intumescent paint thickness tests, all that sort of stuff. So again, it's about demonstrating the point that Craig was making quite strongly, demonstrating reasonable grounds that for signing a producer statement. And one last very comment, and that's on the issue of the time bars on contribution claims, those sort of things. It does occur to me that if you become aware that there is some action going on a project that you have been involved with, even if you haven't been joined in the claim yet, you should be notifying your insurers toot sweet. You know, get it in the system, and that can reduce quite a lot of the pain. I think that's a key thing that we should be thinking about as well. Okay, and that's me. Thank you.
Thanks all. So my name's Hamish McKenzie, former president of CESOC. I'm a principal with Homes here in Wellington, and Nic has asked me to join the panel to just make some observations about what good looks like for signing of producer statements. And so a lot of good stuff's already been covered by our panelists already. But there was a few key things that I thought might be worth adding to that when I think about the processes I go through for reviewing work and or signing producer statements, which I do, you know, reasonably regularly and on behalf of Homes. And it was interesting to hear Adam's thoughts about, you know, what sort of policies and procedures companies should have in place around signing of producer statements. And I was pleased to note that, you know, our firm has most of those things in place. So that's a good starting point. And the Court of Appeal case certainly tightens the sphincter and straightens the posture when you start to think about, you know, your role in signing producer statements. And I think one good thing to come out of it is the clarification that producer statements are important documents, and they have been historically, and despite their lack of regulatory standing, they continue to be important. And so, you know, it obviously flows from that we need to take them seriously and afford them the level of diligence and rigor that they deserve. They're not just something that you fire off at the end of a project without giving much thought to the contents of it. So we need to kind of take them seriously and afford them the diligence and rigor that they deserve. But that, as Adam pointed out, shouldn't happen in isolation. And as Adam sort of alluded to, we need to think and be clear about what our expectations of others are and what others' expectations of us are when we're signing producer statements. in regard to the latter, that might be the client or the building consent authority, or our profession, or ultimately, if things go wrong, the courts. What do those bodies expect of you as the signer of the producer statement? But likewise, what should our expectations be of others? And that might include, again, it might include the client and obligations we might expect of the client or the contractor, subcontractors, geotechnical engineer, other staff or colleagues, or subconsultants, etc. And we should be making sure that our expectations of them are clear and holding them to account for those things when we're relying on them. And Adam made mention of some other good examples there as well. And I think the final thing from my perspective is when we're signing a producer statement or when we're looking to sign a producer statement, we should be prepared to say no, that I haven't got enough information, or there's not enough clarity, or the documentation's not complete, or I haven't got the appropriate PS3s from the relevant subcontractors, and the like. And that sometimes isn't that easy, but it certainly sharps the minds of those that are working for us and around us. If we are prepared to say no, and it kind of collectively raises the bar and makes them realise kind of the expectations that as a producer statement signer you're placing on them in order to certify the document that they're asking you to sign. That's probably more than enough from me. Nick, back to you.
Thanks, Hamish, and thanks all. I see we've got a few questions coming in. While I get into a position where I can read those, one question that came in really ahead of, not even sure if we'd notified that this was occurring, but I may not quite get the wording right, but the point was raised that the Court of Appeal judgment, I think, used words along the lines saying that a producer statement PS4 certifies that works constructed comply with the building code, and raising the fact that in fact that's not what a PS4 states, and that says that they comply or they're consistent with the building consent. So I guess just throwing that out to anyone who'd like to put in some thoughts on the significance of that wording, the reason for that wording change, and what impact that might have.
I can, well, no, in fact, the producer statement, even from 91, the PS4 said that had those words that it was about compliance with the consent rather than the Building Act as such. And from the effectively 2004 Act, that the councils fell into line as well. And so that when they issue a CCC, they use the same wording. And of course, they use the reasonable grounds wording as well. But they also, when they issue a CCC, they're not no longer stating compliance or on reasonable grounds with Building Act, but with what has been issued with the consent. So I think, I guess we're hoping that the Appeal Court judge is writing new law there that, and that those positions will continue to stand. But yeah, Amy, you might have a view on that.
Okay, I might just have to walk up a bit closer.
I think, yeah.
Sorry, great.
I just wonder in the writing up of the Appeal Court judgment whether it was just the interlinked nature of the fact that a consent is processed and given for a project, and that is based on compliance with the Building Act, which is sits under the building code. So whether it isn't just the interrelationship of gets to the same place. Yeah.
I should offer as well, if there are questions from the floor here, we can obviously take those, and we have microphones available. We were looking
just while people are thinking of 100 questions, Noe. just a couple of further things on what Hamish said. I think, yeah, we need to have the fortitude, as we always should, to not be bullied into issuing anything and signing a PS4 if it's not ready, if we haven't got all that supporting reasonable grounds evidence. But the flip side of that is, I think, communication, and I think we need to make it clear at the outset of a project, maybe at the start of the construction phase, or it should be nice and clear in our documentation about what is going to be required. So no one's under any illusions that, you know, before PS3s are issued to facilitate a PS4 and hence a co-compliance certificate, that, you know, X, Y, and Z are provided to us. Don't leave it right till the last minute when the client's breathing down the contractor's neck because he's got tenants wanting to settle and get title and what have you. The other thing too, and I don't want to jump into the construction monitoring piece that CESOC are going to do, but COVID provided us with a number of great tools that we previously didn't have or use very much, Teams and Zoom meetings, and also relying on photographic evidence and video evidence for site inspections. The double-edged sword of that is that I think in some quarters there's possibly been an over-reliance on it. I think it's a great tool to supplement on-site visits, but it's not a substitution. You can't rely on any construction monitoring project is about building confidence with the contractors and the subcontractors on a particular job, and just relying on a few photographs of a nice finished bit of work in one corner of a project doesn't mean that you get the ability to walk on a site and see the whole building process. So yeah, I think and that goes with briefing our site engineers and making sure, you know, especially younger site engineers have the competence and the support back in the office to carry out a particular piece of construction monitoring. I think you know, there'll be a lot that you wrap around it in that advisory piece.
Again, look, I'll add just a couple of points on that too. First of all, again, from my experiences about seminars, and I should do a little plug for that, by the way. There'll be another series coming up later this year. People do seem to get good value from it. But what I've found there is that certainly smaller practitioners, sole practitioners, they find themselves very pressurized to, you know, sign a PS4 toot sweet. So while we can talk about it boldly here, individual practitioners do find it pretty hard to resist some of those things. So that's perhaps something for us to think about, maybe for CESOC to think about how we can give support to individual engineers in that. Another very quick two comments. One is that both relating to MB, but MB are considering sort of in some ways making you know, video inspections as sort of part of the system. And I think for building officers as well as engineers. And also, was a comment earlier was made, they are considering, I think, bringing producer statements, making them a statutory requirement, so bringing them back into the Act. So those are perhaps some other things we'll have to grapple with as time goes on.
Thanks. We've got a few questions up on screen. The first one up there, will a recording be available? Yes, there will be a recording. We've not got a link at this stage, but that will be sent out through various CESOC channels, so keep an eye out for that. Then moving to the actual questions. First one being, what about projects that were designed by Adrian Collis, where Christchurch City Council is asking structural engineers to provide assurance that the work has been done correctly, which the questioner is saying is essentially an engineer after the fact giving something equivalent to a PS4 for someone else's PS1. And are there any thoughts on that situation in relation to the presentation?
I can answer that because it is an issue that's coming up quite frequently in Christchurch. From my personal perspective, I think you've really got to go back to start from scratch, and depending on the projects, I don't think all all projects that Mr. Collis did will be defective, but I think depending on the nature of the work and the scale of the work, it may well be that the only way that you can issue a PS4 is to go back and start the project from scratch, recheck everything, and I think the tricky thing will be is just what the contractor records for the various elements that Adrian and his partners were actually involved in, and how much of it's covered up and not visible. But it's a bit of a myriad that, you know, from relatively simple projects with one ridge beam to you know, more complex residential and light commercial projects. So yeah, a bit of a minefield. I don't think there's any answer, but for me, I think I'd be starting from scratch.
So that's going back to if it appears necessary, performance verification that the design itself works.
Correct.
Yeah.
Just quick on the, I would say that just be very careful about actually using a PS4 in that instance. It's not the appropriate document to use. You know, we can consider producer statement as a generic term, and many of you will be aware we have an A series of producer statements now, and in a generic form, a producer statement is, you know, a professional opinion about something. I would say don't use a PS4 because that's strictly about a consent that has been issued before and that you've carried out construction monitoring on. You haven't done either of those, so it is a more bespoke type document that is required. And if there's a lot of them to occur, then maybe it is, Craig, perhaps we should get together and produce a particular form that would be appropriate for that use.
That is a very good point, because, you know, there is nothing magical about the producer statement suite. It's just something that the industry is familiar with now, and it's a recognised means on reasonable grounds for BCAs to issue a consent. It's the situation that Adam just mentioned is no different really to a client coming back to you years after the fact asking for a PS4. Which should be avoided at all costs because it basically resets your liability clock. So I think in situations like that, it's really just a matter of providing whatever evidence you have, maybe with a covering letter. And in the case of Adrian Collis's projects, with whatever checks you may have carried out, whatever evidence you've managed to uncover, and providing that to the council, and then leaving it up to them to decide whether that's reasonable grounds. Yeah, if a PS4 in that situation can be avoided, I think it should be.
So it's almost something more akin, at risk of crossing terms, to a DSA for the building.
Yeah.
Or a detailed assessment rather than.
Yep.
The next question we've got is in terms of using or issuing PS4s where PS3s are required from various trades, do the PS3s limit the liability of PS4 authors? I guess.
Not at all, no.
So I'm not sure if that microphone's going, but not at all.
Sorry, so we're talking about, say, if the subcontractor has a limitation of liability in its contract or its own PS3, that has no impact on a PS4 between that structural engineer and the BCA.
Yeah, I wonder if the implication maybe is if you rely on a PS3 and that proves to have been
So it's a contribution claim, perhaps?
incorrectly.
Yeah. Yeah. So,
Yeah,
well,
it's going to be quite fact specific.
correct, and that's this contribution claim. So if you've got a claim against you as a structural engineer, and you turned around and said, well, I relied on all these PS3s that are defective, then that's a contribution claim. You need to share in the loss that I'm due to pay. Yep.
I'll make another comment on that. Yeah, you can certainly argue that including a PS3 is part of what you can do to show reasonable grounds, you know, for your thing. So very much important to insist upon that. I've got a bit of bee in my bonnet about PS3s because what we get is there's great variation. Some of them are just a scribbled signature with no name, nothing to it. I've actually produced a perhaps what I hope will become an industry standard for PS3s, which is more akin to the producer statements that we do, which lists the firm, the individual qualifications that they've got, and the fact that they are authorised by their firm specifically to issue these sort of a few things like that. So that I've been publicising that a little bit, and perhaps that's something we need to pick up through the different professional organisations again. Another minor related point is that, of course, construction firms and subbies don't carry liability insurance unless they are doing some element of proprietary design with the thing. So if they make a mistake in a construction sense, that's not covered by insurance unless there is some form of home warranty type insurance.
Covered by contractors all risk?
No. Yeah, but that's an accident on site. It's not a we just got it wrong. Yeah, so if a contractor builds something incorrectly, my understanding is that there's no insurance that covers them for that. If it falls down, sure, there'll be insurance. If it falls down during construction. Amy?
Oh, so the public liability insurance is for damage to property and injury to people, and contract works insurance is when there's been damage to the actual contract works.
Insuring the building.
Yeah.
But again, that's from damage, not from
Damage or defect. Isn't it?
Oh, sorry. Yeah.
Damage or defect.
Yes.
Yeah.
Yeah, I've got a question. We found a defective, a site with defects in it, and the PS1 and PS4 were consequently not appropriate, and the engineer wound his business up straight away. I presume there's no liability for the company because it's a limited liability company. What's his liability, Amy?
It depends how he's related to the business. And if he's a director, and then has he signed the producer statements? Yeah, then you can go for the individual as well. Yeah, but I question whether there's anything behind the individual. Yeah, yeah.
Okay. Oh, Bravo.
Got a slightly different question and interdisciplinary one. So when you have different disciplines working on a project, is it good practice to issue different PS4s by the different disciplines as opposed to a holistic one?
One company.
Yeah. So for example, it could be a structural, geotechnical, fire engineering.
Well, structural and geotechnical, I think you could do together, because if they're covered by the same building code clauses, B1, I think that's reasonable. I would have thought it'd be odd if you did a mechanical services and structural together, and apart from anything else, they have different building code clauses, so it'd be hard to get them on one form. I mean, and I've never seen that. Facade engineers will tend to do, they cover a lot of things. They're very brave, those guys. They'll do E2, B1, B2, all sorts of extraordinary ones, and sign that all on one form. But again, it's all around one discipline, so that's not really answering your question. But I think generally you should separate them. Certainly when they're quite disparate disciplines.
Another practical consideration presumably would be that the signatory should have some expertise in the area they're signing off.
Yeah, good point.
More questions in the room, or we've got another 3 on screen, which we see us through. Christchurch City Council coming up again. taken to insisting on geotechnical PS4s for projects where there is no geotechnical design, i.e. any PS1 is by others. Is there a sound basis on which to decline to provide a PS4 in these cases?
You should never issue a PS4 if you haven't issued a PS1 behind it. In my mind, pure and simple.
Sounds like an easy answer.
Well, again, a corollary to that is that I think more and more now BCAs are asking for PS1s from geotechnical, particularly in Auckland. The metro BCAs, if you like, they're, if it's if it doesn't have to be design as such, but effectively it's geotechnical advice that somebody else is going to rely on, then they're wanting to see it. And I have to say, me as a structural engineer, I want to see that, because it's about what I talked about before. I'm relying on work from somebody else. So to get a, if we're going directly to working with a geotechnical engineer, we would ask, even if they're not designing piles, if they're just giving us design parameters for footings and perhaps piles, whatever, we ask for a PS1, and we are, if not directly through our client, we ask them for it as well. And I think maybe that's putting setting geotechnical against structural, but from our risk perspective, we think that's a good thing to do.
And the last couple of questions are both on PS3s, so I'll sort of run them together. The first is, how do you handle a situation if a contractor refuses to issue a PS3 just because they're not used to issuing PS3s? And then perhaps the related follow-on is that at the moment, essentially anyone can issue a PS3, and should there be rules or guidance or understanding on who can sign these?
Well, perhaps I answered a little bit of that in my previous responses. I think that we should promote a standard PS3, which is perhaps a lot more than what it gives now. The answer to the first bit is, if they refuses, is that, well, that's about what you write, I'm going to say, in your specification. You should, as a requirement, and whether it comes from you or whether it comes from the architect or a project manager, that should be a requirement that they're not going to get paid unless they give us a PS3, in blunt terms. I mean, it's again, it's probably an issue at smaller residential type levels. That's probably not a commercial project problem as stand, but is more at the smaller end, where again a small practitioner has less bargaining power.
Yeah, I'll just reiterate that, and it goes to Craig's earlier comment about kind of fair warning and giving people fair warning of the expectations that you'll have around issuing a PS4 if you've clearly articulated the need for PS3s in your specifications, as Adam points out, and you've reminded them of that expectation at the start of the construction project and a few times in between, and potentially add a sample PS3 as part of your consent docs. Then it makes it a lot harder for them to refuse to give that at the back end of the project. So it's about that fair warning and making those expectations clear up front.
If you like, Nick, I can send you my draft PS3 that I've prepared, and you could send it out to every structural engineer, and let's put it all of us put it in our specifications.
Sounds great. Got a couple more questions coming from the floor from the look of things.
Got it. Jaden here, or Nui. Couple of quick kind of clarifications. We all ask for PS3s, but should we get written to us or the client, or if we're going to rely on them, how do we kind of brief them? And the other one was kind of, is there a bit of client guidance on, like, hey, we're going to ask for producer statements. Is there something we can kind of give to our clients that kind of says, this is documentation we're going to ask for? You should be that should be in either their contracts or anything we can give to them.
Yeah, very much. The first bit, I think it should be addressed to the client, and then it's the client's more likely to back you up, because you're saying, look, this is in your interest. You want a confirmation from them that they think they've done job properly. I say that's something I see often from, also in PS1s and PS4s from proprietary design. So for someone who's doing some proprietary design for a project, they tend to often issue it to their client, that the engineer who's been employed by a piling contractor or something, they will issue it to them. And I say, well, that's actually not good enough. I want my client to be able to rely on this as well. So put my client, the job client, and the guy who's actually employed you on it as well. So that's a bit of a small point, but I think quite important. But it is important who they are addressed to, I think, and that's your point. Does that answer your question?
I suppose if we're going to rely on it to issue the PS4, it's kind of, does it need to come to, which is what I'm saying, is it to us as well? Like, I don't know, coatings, or like we're signing off on some B2 stuff. So if there's fire and durability, and we're going to say it could get messy if it's, say that coating guy goes out of place or leaves, should we be a party on their sort of PS3?
I haven't ever seen that, and I wouldn't suspect that. But I say it should go back to the original client, the owner of the job, if you like.
Yeah, and I suppose the other one would be restricted building work. We wouldn't ask for a PS3 if the carpenter's going to do like a restricted building work document. That is very similar to a PS3. They'll say, I've done subfloor and I've done. That's another document which you can kind of put into the mix.
Which should be called for in the consent, by the council, I would have thought, as the necessary LBP documentation.
Yeah, well, it would be like, I've asked for a PS3 and they say, oh, we haven't done a PS3, but we've got this, and it says, yes, I've followed the.
Yeah, I think that's back to what Adam's frustration with, being such a disparate number of these forms. If we can pull it together in a recognised standard suite, I think it'd be for everyone's benefit.
I think, look, at a residential level, that if you have got a properly filled out, I can't remember what that form's called, that then that's probably reasonable. Of course, when you've issued your PS1, you've also issued a Form 2 memorandum, right?
Yeah, we'll often put on the inspection schedule that the client shall supply, the contractor shall supply. We want to see a PS3 and we'll see coatings, and we'll put that in the inspection schedule, and that often will come through on the building consent. It'll say to be supplied as.
That's a good way to do it, because and of course, it's a firm message from Engineering New Zealand and ACE is to, if you are issuing a memorandum, always issue a PS1 as well. There's just a bit more protection that comes through to you from that.
Yeah, just wanted to follow up on something said a bit earlier. So were you suggesting that construction contractors arguably should have professional indemnity to cover the scenario where they build something wrong, don't follow the plans, screw something up, as opposed to just construction insurance?
Contractors will only hold PI if they're doing design. And so in a construct only, it'll be a temporary works, possibly, normally quite standard. Yeah, but not PI, no.
That's my understanding, that nobody has it. And I was just curious as to whether Adam was suggesting that's a problem.
Well, in terms of the PI side, say again, if it's a contractor who's doing proprietary design, and so the obvious examples for us are screw piling, for example, or precast ribbon and fill flooring, something. So that's doing specific design, and so you would expect those companies to have professional indemnity insurance to cover if they make a design mistake, but that won't cover a construction mistake. Now, Amy Craig is saying that some construction mistakes will be covered by contract works insurance. That's not something I've seen a lot of effect being applied to. But
Yeah, a little bit complicated. Some. Yeah.
does that answer your question?
PI only relates to design. Yeah.
Supposed to be doing design, screwed up, it's not an accident.
Okay.
Bad luck.
I guess my rationale is that when you see serious cock-ups like that, the builders tend to go out of business, which suggests to me that they don't have adequate insurance to cover it. But my colleagues here tell me that there is some levels insurance available. Just getting back to the PI, if you are doing a performance specification for some design by a contractor, part of the requirements again within specification is that they do have PI. They're going to give you a PS1 and a PS4, and perhaps if you're extra serious, you're going to ask for demonstration that they have got PI insurance.
I think I kind of got a bit confused as well, but I think what we're saying is we're saying it's built right, but if the builder doesn't build it right and we're not looking at it and we're saying it's built right and it falls over, it'll probably come back to us, not the contractor. If the contractor say he's built it right but hasn't built it right, then that's that kind of that quasi PS3, PS4, we're relying on someone else's thing.
We would get dragged in on a contributory negligence basis. It's the same as any claim, and it's why engineers are such easy targets, because we've usually got the deeper pockets and the more robust
and the smallest fee
insurance policies and the smallest fee. I think in the time I've been on CEAS, the record for an engineer being drawn into a claim is about 14th defendant for designing one beam into a leaky building, and often you end up paying some money to avoid going to court, because most of the people above you in the defendants list have either got no insurance or have gone broke or disappeared to the Gold Coast. I think, just as we're asked to provide evidence of our policies and the strength of our policies and our level of PI cover and PL cover, I can't think of why any construction contract, large and small, the contractors wouldn't have to front up with evidence of their contract works cover.
And ultimately, in a building claim like that, the two people in the firing line is going to be council and the contractor. Yeah, so the contractor's on the hook under the building contract. Yep, and then consultants, engineers, so forth, are normally joined by the council contribution. And onto your PS4s, your PS2s, and so forth. Yeah, so the contractor will be there. Yep.
I just reflect perhaps slightly different topic, but that, when Amy, you were talking before that the courts have to find, beyond reasonable doubt that there's a bit of an elephant in the room there. The Bella Vista case was particularly bad, but, if one of these cases comes up and, defining that trying to get a bit of definition about what reasonable doubt is, because of course we will argue that our construction monitoring regimes is that we don't have to see everything. It is all the categories. It is random selection of observation. So when we put our hand up and say, well, actually, I looked at 5 concrete pools, but there were 7, and I didn't see that one. Was the one that I didn't go to, but I've still done what's expected of me. Now, what's the Supreme Court judge going to say about that? That's something for us to look forward to in the future.
Nic, could I just quickly go back and just qualify my rather simplified answer to the Christchurch City Council Geotech question about, don't issue a PS4 if you haven't issued a PS1. I think that's another example of different means of demonstrating to the BCA on reasonable grounds that work has been carried out. And I think this question has been raised by a couple of geotech engineers because the request is coming from Christchurch City Council, and I'm sure there'll be other BCAs about basically standing up and certifying what you've done. But if a PS1 hasn't been issued by a geotech engineer, but they've important body of work, the geotechnical investigation and report that everyone's relying on, and then they've been engaged to carry out bearing tests and tests as the construction's proceeded, I'd expect the geotech engineer just to basically provide the evidence on that basis as a way of demonstrating on reasonable grounds to the council that they've followed through and that what has been uncovered on site is as they are expecting. Again, there's nothing magical about a PS4.
Okay, we've got a couple more questions on the screen, but I think one of them's already more or less been answered. And question saying, should BCAs be requiring PS3s? And I think that came through in an earlier answer that yes, whether that's through, ideally they should be, whether that's through the engineer's specification or their own NAS. The last question, I'm not sure if we've probably got time to get into it, but maybe Amy can provide us with an answer to what exactly is reasonable grounds. But I think there's no easy answer to that. So
it's fact dependent. So every case will be different. But
so with that, I think we'll draw a close to things, other than to say, Craig, that the other day, just to one up you, we came across an engineer who I think was the 32nd third party to a claim. But say no more on that. But otherwise, if we could all just thank our panelists, and we do have a small token of CESOC's appreciation for the time put into this, but it's been illuminating for me and I hope for others as well. So thank you all.
I strongly recommend it. Anyone who hasn't read the practice alert advisory, read it. It's I think it's a very good piece, and also the judgement. As far as being a cure for insomnia, it's actually it's not too long. I'm sure Amy daily reads far longer ones, but it's actually really interesting. That just the amount of detail that it does drill into on the Building Act and what it means, everything that we do.
And after if you read it, you certainly won't get to sleep.
On that happy note, we'll call a close to proceedings, and thank you all for coming along.